Hello. Hello.
Sir, can you hear me?
Yes, ma'am. Very good evening to you.
Perfect. Good evening, sir. Good evening. Sorry, we have joined a little late. There were little glitches. Really sorry, Awab, sir.
No issue.
Good evening, sir. Bhatia, sir. Good evening.
Trying to talk to you people. You're not there. So I finished my tea.
Sorry, sir. Sorry. We have been a little late.
No,
Very
no, you missed the tea.
A very pleasant evening to all the panelists and the participants who are connected with us. It is our pleasure to connect with you all. I welcome you all for today's session, which is on the topic simplifying IPR and patent filing. Our expert for today's session, Mr. Awab Habib Faki, sir, has already come to the session. This is for your information, dear participants, that the recorded video of this session shall be available on our YouTube channel at the earliest by the end of the session. The details of our YouTube channel will be shared on the chat window as well. Further, I would like to request you that you can access your chat window. Dear participants, whatever device you're connected through for today's webinar, kindly ensure that you all can access the chat window from the same. I repeat that the chat window is an important mechanism through which we all will be communicating during the webinar. So any questions that you will be having, you can write on the chat window. I shall be facilitating asking those questions, but at the end of the webinar. I also request all the participants that we will be sharing a feedback form link on the chat window for automated generation of the certificate of participation for today's session. Dear participants, kindly ensure that you are. Bhatia sir, your audio is on. Dear participants, kindly ensure that you're connected with us till the last of the session and you own yourself a certificate of participation of this session despite increasing your knowledge. We will be starting soon. New prospective authors may kindly note that Bidget, being Scopus indexed, published by Springer Nature, accepts only original research papers in computer science and its application domains, but not the review and survey papers. However, keeping in view the NEP 2020 recommendations of undertaking multidisciplinary research, we are happy to announce International Journal of Research in Multidisciplinary Studies. It's an official publication of Bharati Vidyapeeth's Institute of Computer Applications and Management, which is published biannually by the Institution of Media Professionals, New Delhi. Interested authors from any domain can submit their papers online at our website in single column in the template which is available at the website of BBICAM. I will be sharing the links with you shortly in the chat window. Dear participants, whatever device you are connected through for today's webinar, kindly ensure that you all can access the chat window from the same. I repeat that the chat window is an important mechanism through which we all will be communicating during this webinar. So any questions that you will be having, you can write on the chat window. I shall be facilitating the same by asking those questions, but at the end of the session. I also request all the participants that we will be sharing a feedback form link on the chat window for automated generation of the certificate of participation for today's session. Dear participants, kindly ensure that you are connected with us till the last of the session and you own yourself a certificate of participation of this session despite increasing your knowledge. I would share the information once again that new prospective authors can kindly note that widget, which is Scopus indexed and published by Springer Nature, it accepts only original research papers in computer science and its application domains, but not the review and survey papers. However, keeping the NEP 2020 recommendation of undertaking multidisciplinary research, we are happy to announce International Journal of Research in Multidisciplinary Studies. It's an official publication of Bharati Vidyapeeth's Institute of Computer Applications and Management, which is published biannually by the Institution of Media Professionals, New Delhi. Interested authors from any domain may submit their papers online at the website of BBICAM. I will be sharing the link for the same on the chat window shortly. You can submit in a single column in the template available. For more details, you can refer to the journal homepage, the link of which will be shared with you on the chat window. Please note that there is no publication fee. For the participants who are unaware of our chat window, Awab Faki sir is sharing some important information on the chat window. Feel free to post your questions on the chat window. Kindly note, whatever device you're connected through for today's webinar, please ensure that you all can access the chat window from the same. Today's chat window is very active. I repeat that the chat window is an important mechanism through which we all will be communicating during this webinar. So any questions that you will be having, you can write on the chat window. I shall be facilitating the same by asking those questions. I also request all the participants that we will be sharing a feedback form link on the chat window for automated generation of the certificate of participation for today's session. Dear participants, kindly ensure that you are connected with us till the last of the session and you own yourself a certificate of participation of this session despite increasing your knowledge. Participants are free to connect in the chat window and answer the questions posed by Awab Faki sir. I welcome you all for today's session, which is on the topic Simplifying IPR and Patent Filing. Our expert for today's session, if you already don't know by now, is Mr. Awab Habib Faki. Sir has already joined us and is very active on the chat window. This is for your information, dear participants, that the recorded video of this session shall be available on our YouTube channel at the earliest by the end of this session. The details of our YouTube channel will be shared on the chat window as well. Further, I would like to request you that you can now access your chat window. A very pleasant evening to all distinguished panelists and participants. Bharti Vidyapeeth's Institute of Computer Applications and Management, in association with Computational Intelligence Society chapter of IEEE Delhi section, Computer Society chapter of IEEE Delhi section, Technology and Engineering Management Society chapter of IEEE Delhi section, System, Man and Cybernetics Society chapter of IEEE Delhi section, Communication Society of IEEE Delhi section, Consultants Network Affinity Group of IEEE Delhi section, Life Member Affinity Group of IEEE Delhi section. Okay, sir, I can hear you.
Hello.
Yes, sir.
Yeah, you have completed. I was talking somewhere else. You have started or what?
Sir, your audio is on. I have started, sir.
So you please go ahead.
Okay, sir. A very pleasant evening once again to all the distinguished panelists and participants. Sorry for the technical glitch. Bharti Vidyapeeth's Institute of Computer Applications and Management, in association with Computational Intelligence Society, chapter of IEEE Delhi section, Computer Society chapter of IEEE Delhi section, Technology and Engineering Management Society chapter of IEEE Delhi section, System, Man and Cybernetics Society chapter of IEEE Delhi section, Communication Society of IEEE Delhi section, Consultants Network Affinity Group of IEEE Delhi section, Life Member Affinity Group of IEEE Delhi section, Inter-Society Relations Standing Committee of IEEE Delhi section, Industry Relations and Special Interest Groups on Humanitarian Technology Standing Committees of IEEE Delhi section, with the associations Computer Society of India, Institute of Information Technology Professionals, ISTE Delhi section, and IETE Delhi Center as technical collaborators. Welcome you all to the webinar on simplifying IPR and patent filing. It is a moment of pride and honor to announce that we, with united hands, mark special contribution for the monumental occasion Azadi Ka Amrit Mahotsav, which is an initiative to celebrate 75 years of glorious independence by organizing the thought-provoking sessions for our better future. This webinar is an initiative for celebration of Azadi Ka Amrit Mahotsav. Inventions cannot be judged on patent parameters, but the patents have the ability to take the inventions so far. With the rise of intelligent and with the rise of intangible assets that we are with the rise of intangible assets that are shared across the internet, it is easy for people to unlawfully copy and share books, music, movies, and more. Copyrights, patents, trademarks, and trade secrets, and the laws around these protections are all intended to encourage innovation and curb illegal activities. The webinar will discuss the Indian patent filing procedure, unleashing IPR, display of various patent design, patent filing journey from application to the grant stage. I would first take this opportunity to welcome amongst us our distinguished panelists for the day. I now request Professor M.N. Hoda, Director, Bharti Vidyapeeth's Institute of Computer Applications and Management and Vice Chairperson, IEEE Delhi section, to address the participants with his inspiring words.
Good evening to everyone. And at the outset, let me take this opportunity to welcome Mr. Awab, who has been very kind to me, to Bharti Vidyapeeth, and never says no whenever I request him. So he is with all of us to inspire us, to make us to understand, to educate us that why IPR is important and how we should go ahead for whatever activity we are doing to get it protected if it is innovative, if it is of worth some asset. And IPR will be the biggest asset, not our house, not our car, not our other belongings. So thank you so much, Mr. Awab, for having accepted my request and being with all of us. I also take this opportunity to welcome all my friends from various professional societies who keep on joining for these webinars, which is 122nd webinar in the series of IEEE, IETE, BVI Camp webinar, weekly evening webinar series. Dear friends, the today's topic being simplifying the IPR and patent process is very important, very apt for a very simple reason that all of us should know that if we are creating something, how to take or how to get ownership of that. If we are publishing, and we are not getting ownership, Probably tomorrow, if we need that work, someone else may claim it and we may not. So it is very important to understand this, and that's how we have invited Mr. Awab. And I take this opportunity to thank to all of you who have joined from various parts of the country for this particular webinar. Though in the month of June, we didn't conduct the webinar because there were vacations, there were other activities in the campus. So we thought the way vacations and breaks are being taken by everyone in every profession. So this webinar for a month will be on vacation. So we were on vacations. Now we are back. We have notified five forthcoming webinars which are open for registrations. If you have not registered so far, please register for those webinars and also register for some other activities, link of which shall be shared in the chat window. Dear participants, also note that at the end of the webinar, the feedback link shall be shared. If you fill up the feedback link, you can generate your certificate. However, if you are not interested in getting certificate, you may skip that step. If you do not fill the feedback form, write through the chat window and keep on writing us on our email or maybe on WhatsApp or maybe on some another medium, we may not be in a position to help you out. So with this note, I would like to conclude and keep the opportunity available and the time available for my valued speaker, Mr. Awab, today, that now from today onwards, maybe every week or alternate week, please go through the schedule. We'll be meeting for almost Saturday evening with new and new topics and very apt topics. So the break is over now and we are back in full swing. With this note कि फूलों की तरह फिर खिलेंगे हम, फूलों की तरह फिर खिलेंगे हम, और अगले सैटरडे एक नए टॉपिक के साथ फिर मिलेंगे हम. Thank you so much. All the best. God bless you all. Over to you, Priyanka.
Thank you, sir. I would now welcome amongst us our expert speaker, Mr. Awab Habib Faqih, sir, with an e-bouquet.
Thank you, ma'am.
Welcome to the session, sir. I would
Thank
just
you.
like to give a little introduction about you to our joinees in the session.
We are setting up the service.
With firm belief in innovative education and years of experience in entrepreneurship, Mr. Awab Abib Faqih, Director of Student Alliance LLP Mumbai, is a multifaceted professional. He has established his own edtech startup, conducting independent research and patenting several innovations. Also, he is a startup mentor at the Atal Incubation Center and as the mentor of change at the Ministry of Commerce and Industry, Government of India. With many awards and recognition to his credit, he is an educator at AI Kalsekar Technical Campus, an edupreneur, a patent analyst, and a researcher. He has numerous patents filed till date. Mr. Awab is also on the governing body member of Everest College of Engineering, Aurangabad. He's the member and advisory board member, Board of Studies in IPR Cell, Maulana Azad University, Jodhpur. And he is undoubtedly an experienced professional in the domain of patent grant and filing. We are privileged to have you amongst us today, sir. I welcome the great visionary to this session and would now request you, sir, to kindly enlighten the house. Over to you, sir.
Thank you, ma'am. You were extremely kind with your words. Thank you so much, ma'am. Ma'am, if you can really guide me, like how I can use the chat window while presenting my presentation, if you can.
Yeah, Mr. Awab, it is visible.
Okay, sir.
Yes.
The presentation is visible. You can put it in slideshow mode. And you are audible as well.
So I just wanted to use a chat room. Just was finding out where I can.
Okay. So for chat, you need to see that, huh?
Yes, I'll do it. I'll do it.
After Webex is put in live as a presenter, it goes here and there. So bring your cursor down, bottom at the bottom, you will get it.
Sure. Hmm. Yes. Hi, very good evening to everyone. Just with the chat room, I can expect that all our very senior dignitaries who have already joined with us. So I'll make sure the coming 41 minutes, I'll make sure it should be very worth it. The complete a short journey of patent journey as how it is really processed. People who have really attended the webinar initially, so there would be like 40% a little more advanced modification to the presentation, what we have already done it. Let's start with this. The first thing, every people have or every innovator, every academician normally usually have a doubt. Okay, what are the major factors, right? So whenever you're assuming, let's start on a positive note, like you have already worked on some project and that is very inventive, innovative, and so on and so forth. Like you feel, yes, we can go for a patent. So let's talk on a positive note. If you feel so and your work is ready, these are the three major criteria where your examiner, when I say examiner, that means the person who is there into the patent office. So I'm referring to him. So I'm referring to that person. The examiner will have a three checks, like if it is novel or not, if it has an inventive step or not, and capable of industrial application. So these are the major three categories which is mentioned in the Indian Patent Act and so on and so forth. So just to explain you with some examples, like when you talk about novelty, my dear friends, like for example, if Aarti, Achar, and Ajay would question me, okay, well, like when you talk about the first criteria with novelty, what do you mean by that, right? So when you talk about usually I take this common example. So if you talk about watch concept, the watch is like completely a very old concept, right? So like Ankur will say, okay, well, okay, watch won't get patented, right? Right, Ankur is completely right. When I say novelty, that means I don't mean by if like it should be like completely new. It should be an inventive, right? It should add a value to it with the current existing model. So in that case, for example, if I talk about watch and if I say key like our complete team comprising of we have a number of good people over here. So we have Bhakti, we have Basant, we have Brijesh. Sorry, I'll be calling you by first name, assuming you are very senior to me. So we all the three people would be working on it, and if they feel, let's do some modification on watch concept. So they were very successful in making a transparent watch, and they were also very successful in converting that transparent watch into a computer by using a chip and so on and so forth. So the concept which was there, the watch concept which was already patented, right? And they added some value to it. So that satisfies the first criteria, right? And the examiner will judge it to what level it satisfies the criteria. When we talk about the second step, inventor step, if for example, if Brijesh is there with us, we have Brijesh, we have Dr. Anupama, we have Dr. Bhuvaneshwar, Dr. Pradeep, Dr. Reena, if all these people were into group A category, okay? And we have group B category. We would have be having Dr. Ritika, Dr. Arun, Dr. Evan, Dr. Deepak ji, Dr. Indu, Dr. Krishna, Dr. Pushpinder ji. Okay. So these people, all these people would be in group B. So we have a group A. Group A people have already got a patent. Okay. From the Indian patent. So they have already got the patent. They have made a drug for a cancer, which definitely kills the cancer cells, but they also kill some of the healthy cells too. And that drug is available for 8,000 rupees in the market. Okay. Group B were thinking, yes, they are solving a really big problem. Why not we are also having that kind of expertise? Why not we also develop that kind of drug? Since that was already patented, so Group B started working on it, and coming 18 to 20 months, it was rigorously working with putting all the intellect in the work, and they were successful in making that drug. They were really successful. The Group B was successful in making the drug with a different chemical composition. So my first question to this amazing audience, what we are having over here, what do you feel if the group B was already having a patent, right? But the chemical composition was different, but the group B could also make the same drug, but with a different chemical composition. Will that group B will get a patent or not? What do you feel? So if we can just mention to the chat room, we can just discuss with the scenarios. It will be really easy for us to understand how exactly the patent really works. So we have got answer from Dr. Ritika. Thank you so much for putting it. Yes, Gunpit sir, we have got answer from Gunpit. Subhash ji, thank you so much for making Dr. Sayeda. Thank you so much. I very difficult to call all the names. Sorry for that. But assuming people have understood that Group A is already having a patent, and Group B understood that yes, we are also having that kind of intellect that we can also develop that kind of drug which can really help a common man, right? But the point is that how your patent application, my dear friend, is processed in the Indian patent. Just understand that. Okay. One part is like working really hard and making sure that by all these three criteria is justified. And the second part is that how exactly your documentation will be processed in the Indian patent law. So the examiner will judge it. Okay. Group A is already having a drug into the market, and that is for 8,000 rupees, for example. Okay. And they will check your drug too, and they will say, yes, even that drug is made for different chemical composition, and the effect is exactly the same. Effect is also the same. Then he will check what is the financial factors for it, and he will say the group B will also say yes, we have made this with a different chemical composition, but even the pricing is not changed. We have not increased the price. The pricing was also the same. It is for only 8,000 rupees. So examiner will not be able to find any major distinguished factor for to process your patent application ahead. Just understand that. There have to be some enhancement to economic and technical factor. Either the group B have to prove, yes, the earlier drug which was there into the market could definitely kill the cancer cells, but they were also killing the healthy cells. In our case, the healthy cells are not killed and so percentage. It is only impacting the cancer cells. In that case, it would have an added advantage. Or in any other case, they would say the effect is the same, but by using a different chemical composition, we could lower down the economic factor of that particular drug. Which was available for 8,000 rupees into the market. Now we have brought it down to 1,500 rupees for the cancer patients. So there has to be some added advantage, my dear friends, to make sure your patent application is processed ahead. And third is like we talk about a capable of industrial application. There have to be some industrial application towards it. It's seriously depend upon the product to product. But the second step is seriously, rigorously test by the examiner before it is forwarded to the controller. Like how do we submit our this thing? Whenever we write an assignment during our college day, we used to submit to the monitor, and the monitor used to give it to the class teacher, right? So that is the first step. So that is the way it works. So let's go for the second slide, my dear friends. Since as we have started with a very positive note, understanding that everyone is really technically sound over here, all the 170 people who have joined. So everyone is really sound in their own factor, in their own technology, what they're working for it. Let's assume yes, we are working on a patent application. How exactly the application is processed, how exactly the application is made, and so on and so forth. Assuming all the people, like we have 121 attendees as of now, assuming all the attendees over here are having their own patent. Okay, so for now onwards, I would be calling patentee Dr. Vinay, patentee Jayashree, patentee Dr. Ruksar. We have good people over here. We have patentee Fatima, patentee Faraz ji, patentee Mukesh ji, patentee Gaurav ji, and so on and so forth. So everyone in the chat room, assuming, at least for me, they all are patent, even if you have not. But I'm assuming you have already worked in your career to that level that there have to be some amazing technical or innovations you guys have done it in your career. So assuming all are patenting, that means a patentee is termed only if you are a owner for a patent. So whatever work what you have done, if you have gone to the patent application and all the process you have done it, and the patent is granted. So now you will be termed as a patentee. So now you're an owner for a patent. So as director sir said, like as how you have an assets, right? You have car, house, and so on and so forth, right? If you talk about property, so property, if you're having a property, either you can lease a property, either you can sell a property, you can make a money for it. Similarly, my dear friends, a patent works in that manner. But you need to be very, very smart. What is the criteria, what is the market going in which direction, and accordingly you have to make sure it should really contribute, so that we'll be taking it much ahead for it. So assuming all our innovation have been patented, so you are termed as a patentee. So patentee has various options where they can make money, where they can make sure either they can make money, either they can make some social impact into the society, and so on and so forth. It's completely your choice for it. So once a patentee is having our own invention, and but obviously if it should add some value to the market. So there are various people or industries or companies or technological partners who will come and will give a proposal to you, so that they would need your patent for XYZ duration. If you would question me, what is the lifespan for a patent? If anyone could answer the lifespan for a patent into the chat room, if you are already aware of it, what is the lifespan for a patent? Because if you are aware of it, it will really help for the other attendees. Yes, someone really answered it. I think that's Priyanka ma'am. Thank you so much for being so sporty, ma'am. So the lifespan for a patent is 20 years. It's from the day of application. So till 20 years it is once it is granted. So during that, since you are an owner, so you have multiple options for it. Either if there are people who are approaching for you, either it could be a technological, manufacturing, and so on and so forth, a chemical industry. It depends upon your product, depends upon your invention. So either you can give it your patent for XYZ duration. It could be 3 months, 2 months, 3 years, 4 years, 7 years, 10 years, 11 years, whatever it is, depending upon the situation. Either you can give it on rent. How we sell a property or rent a property, it works in a similar fashion, right? So either if you are transferring a patent rights, my dear friends, if you're selling a patent, for example, we have a patentee for us, right? So he's already owning a patent, okay? He wants to transfer it to someone. He wants to sell it to someone. So for example, we have Gaurav Gupta ji with us, okay? So Gaurav Gupta ji is owning a XYZ company for it. He's a technological technologist. He is looking for that kind of patent so that it can add value to his own company. He's approaching to a patentee for us, and they have XYZ deal for it, and the complete patent ownership is transferred to Gaurav Gupta ji. So in that case, Gaurav ji will become the assignee. So it works in that format. Let's take some other example. What if Dr. Faraz feels ki no, let's not sell it. Let's do a licensing part. So we need to really understand what is the lifespan of our product. That should be very, very clear. We should be very smart with the market, where the market is moving for it. I'll give you a scenario. How do you judge it? I'm assuming we will go for a patent. We will have a patent in coming few months, coming year, and so on and so forth. Let's say even if we have it, how to utilize it in the best format? So you just need to be very, very smart to analyze what is the age of that patent for it. Like Priyanka ma'am already said, yes, it is granted for 20 years, but we should know by what is the value in the market. Will it survive for 20 years? Will it be continuously adding value continuously for 20 years? Yes or no? If you feel no, it will be adding value for only 10, 12 years. In that case, what to do? What if you feel no, it will only add value for 2 or 3 years or max to max 4 years? In that case, what steps should be taken for it? If we feel okay, yes, the duration is very, very small. So it is very wise so that you can sell your patent to some other entity and move out. So in that case, Gaurav Gupta ji was a company. He had approached Dr. Faraz and he sold his patent. So Gaurav Gupta ji was assigned. What if you feel, can you channelize your team gives input? Yes, it has a very good lifespan, at least for 8 to 12 years. In that case, my dear friends, why not go for a licensing? Again, in licensing, there are two types of licensing. One is known as exclusive, one is known as non-exclusive. Let's understand both the kind of licensing and understand the scenario as well. I'll be putting up a question so that to make it easier for you to understand. For example, you have a product design, okay, and you want to license it. So you have two options, A and B. A is exclusive license and B is a non-exclusive license. So you tell me what is a better option for it, okay? For as everyone is the owner for a patent, and you are having two options, either to exclusive or non-exclusive. Exclusive as in your patent is valid in India because it is valid only for that particular territory, for that particular country, right? Since you have filed application in India itself, right? So it is valid in India and you give a right to XYZ person in Maharashtra, Delhi and UP or so on and so forth. And that person will be having an exclusive right for Pan India to manufacture and to sell the product. And there is a second option where you have a non-exclusive, where what do you do it? You give license in every state and say that this is your territory. You cannot go, you can have an interested trade and so on and so forth. So you give license in every state. So you are giving license in 8 states, for example, and they are manufacturing it and they are having a trade and they are doing a business for it. So being a patentee, what do you feel? Which option you would prefer? You would prefer option A or B? You can just write A or B. A is exclusive. You are giving a right to only one person in Pan India, right? In that particular territory. And option B is that you are giving rights to 8 different people in 8 different states. So as a patentee owner, which option you would prefer? You can just mention A or B. A is exclusive, only one license in Pan India. B is giving license to n number of people, for example, 8 people in 8 different states. So that's a scenario for it. So when you have a patent, you will have this kind of. Thank you, Piyush. And thank you for putting an answer. Thank you, Dr. Indu. Thank you. Thank you, Rakhi. Thank you, Basant. Thank you, Dr. Saida. Thank you. So in that case, let's make me understand like how the decision would be easier for you. If you feel the design span of that product is something for a longer duration. So in that case, you need to make sure you should go for an exclusive so that once you in India, especially in India, once you give to license to n number of people, there are high chances that the designs would be pirated and so on and so forth. And tracking in India again become difficult. Again the law, judiciary, and so on and so forth. That is a different way out. But if you feel so that the lifespan is very, very small, so getting into B option is very good because you know the lifespan is already very small. So you need to expand very aggressively before it becomes very common, before someone else take that design and make some better improvisation for it. So you need to really understand the situation once you have a patent for it. If you need to really commercialize it, or you need to make sure you are creating a social impact. So that's a small brief over it. Let's move ahead. Let's understand some terms into a patent office. How does it work? Someone like Priyanka ma'am or someone had put me a question, what do you mean by patent agent? Is patent agent compulsory and so on and so forth, right? So let's have a brief over it. Like how we have when you talk about Bharati Vidyapith, for us, how we have a director over there, right? Similarly, a patent office has a controller who takes the highest authority and so on and so forth. Once all the all the documentation which is processed by the examiner, it goes to the controller, which is the highest authority to either to grant a patent or reject a patent. Okay. When you talk about opposition board, okay, let's understand by taking few of the scenarios. Okay. So we have Kamalji with us, we have Kausar Ali with us, we have Christian with us, we have Sneha with us, we have Madhu, we have Mahfuz, we have Mamta Devi with us. Okay. So all these people, assuming they're into one group, and they were working really hard for a invention. Okay. They were working really hard for invention. In that particular case, they came across that there is already an entity who has published the patent, which is working on the similar lines what they are already working on it. So there are high chances when this entity would apply for the patent application, people who have already, the group who have already filed for a patent application, they would grant for an opposition for them when they keep on processing the application. In India, my dear friends, like few would question me ki uh, how do you judge it? Like what kind of opposition we have? Do we have only pre-opposition before the grant, or do we also have post-opposition? Even after the grant, can you oppose it or not? My dear friends, in India, you have both the options. You have pre-opposition as well as post-opposition. So you have that kind of flexibility. The government are given that kind of flexibility where you can oppose it and you can fight for your rights, for your invention too. Next, we are talking about patent office. So there are two options. One is a physical, one is the online, right? In fact, government is supporting for an online application. They have reduced the price by 10% so that people should be very competitive and very comfortable with filing an online application. And for offline, we have four major centers, right? I'll be briefing you about the areas too for it. Next is a patent agent. My dear friends, your patent agent, like someone said me, is it compulsory or what to have a patent agent? The question is, yeah, and the answer to that question is no. Patent agent is not compulsory to have to filing a foreign patent application, my dear friends. You can file a patent application by your own self. No degree or no any specific degree is required to file a patent application. Even any academician, any educator can file an application, irrespective of whatever qualification he is having for it. Patent agent are people who are having a knowledge of patent application. So if you feel your expertise is extremely good into the innovation technologies part and so on and so forth, you don't want to venture yourself into the documentation segment, and you would need a third entity to make you understand how to draft an application, how to process an application. Only in that case you go for it. And many of you, I think, since I'm assuming many of the people would be from Delhi and so on and so forth, you might be aware of a DPIIT, right? So that is a scheme for government which is being run for the patent application, because that is a region the patent application have risen from last 4 years. The percentage is rising on almost like between 15 to 23% year on year in India. Because in that particular category, what if you are a startup, you have a startup number, right? So your completely the application fees has been waived off almost 5 by 80%. And in that case, even the patent agent are there on the government websites who will do your application, filing everything for free of course, because they are getting paid by the government. So many of them are not aware of it. The only thing is that you need to have a startup number. So what I usually say to all the academician, so for example, you have a batch of 60 students, right? So assuming in 60 students, you have 17 groups who are doing the graduation project or so on and so forth. And you can, as a forming a committee, you can just chalk down which are the projects who are really good and you can really go for the patenting. So if you feel among 17, two can really qualify the patenting application, so you can just apply for the Startup India startup registration, and that is free of cost, and you can get a startup number for that particular project, and from there you can apply for your patent application. Since once you have a startup number, so you get all the benefits for the patent file, so you can work in that way, so it will really be helpful for you. And next is a patent register. So patent register, what is that? Once a patent is granted, so once you sell your patent, once you give your patent to licensing, any transaction, any documentation part, whatever transaction you do with your patent, all that is maintained with the patent office. So that is the overview about the patent office, my dear friends. Some people have raised a question about FER report and how we'll be submitting an FER report. Thank you. We'll be doing it, sir. So that is the FER report is basically like whenever you submit an application, sir, either it could be a provisional application, either it could be a complete application. So once you do your complete application process, so if there is any query which is raised by the tech team, by the examiner, so that is known as an FER, which is generated, and you have to answer it back to them. Either it could be a design patent, either it could be a utility patent. There are two kinds of patent, sir. One is known as a design patent. What is the difference between both the patents? When you talk about design patents, sir, it is you only talk about design, you don't talk about the working. You only talk about 2D and 3D. That's it. So that is the simplest form of patent. Where initially, once you're focusing on the yes, even you want your students to go for patenting, you can start with a design patent, because over there you don't need to write all your claims, because when you talk about claims or claims, for writing a claims you need a little expertise for it. You as an academician can definitely get that skill within a month or 45 days or 2 months or 3 months. That's it. For students it will take some time. And second category of patent is utility patent, where you need a design, you need a working, you need claims too. So that is the one. So claims is very, very important. For on what basis you are asking for a patent. And you also need to mention the working as well. But in design, you don't need to mention the working. So that is the way, that's an overview about it. So let's understand much more detail about it. Okay. So for example, let's take a scenario again. So we have Navjeet, we have Muktaji with us, we have Kausar, we have Jevita, we have Fatma with us, Jayashri with us, Dr. Vaishali, Dr. Shristi, Dr. Sapna with us. We have Dr. Reena with us. We have Abraham sir with us, Bhavesh ji with us. Okay, so all these people they're forming a group, and they're questioning to me, what if we as a team are working on a project, and we know that our competitor is also working on the similar lines. We are very well versed about it. But we have only completed the 80% of the work, 20% of the work is still pending. And we know that they haven't touched 80% of the work. What should we do? Should we file a patent, or should we complete our work and then file a patent? That is the scenario. Just understand the scenario, my dear friends. It will be easier for you to understand the patent application and process, because the agenda is not about completing the slides. You are extremely senior to me. The point is that if we have group A, okay, group A, all this name which I have said it, they are into group A. They question it to me, we are working on an innovation or invention. 80% of the work is completed, and our competitor is also working on the similar lines. We know that. And they haven't touched 80% of the work. And we have completed 80% of the work. Can we file a patent? 20% still remaining. It will take more 10 months of time to complete that work. Can we file a patent or not? So what do you think, my dear friends, my colleagues? What should be the answer? Yes or no? Can I file a patent? Yes or no? If you can just write Y or N, that's it. Thank you so much, Priyanka ma'am. Thank you. Thank you, Mamta ji, Kausar ji. Thank you. Thank you. Thank you, Deepak ji. Some Mamta ji, Kausar ji, and people few are saying yes, few are saying Guru, Kaur Gambuji, yeah, but provisional specification. To the point. Thank you so much for putting up that, sir. Krishna Kanji. Okay. So few are saying it yes, few are saying it no. I'll just brief you about it. Thank you so much for putting it, because you guys are booster energies for me as of now for today's session. Thank you, Sudhir ji. So the point is that in India we have a provisional application in which you need to only submit the abstract and drawings. Even if we don't submit the claims, you can apply for the provisional application. So that's the beauty of it. But the important point over here is that you need to complete your provisional application within 12 months. That's the reason I said they feel they will complete the work in 10 months. If they feel so, they will be completing the work within 12 months. They can directly go for the provisional application. And then again, they can go for it. And few would question me, you said it ki bhai, Bala Bhaskar, yes, with parameters, yes. So when you talk about parameters, sir, in this case, abstract and drawing is important. Without this, you cannot go ahead. Thank you so much for putting that point, sir. And when you talk about complete application, as Balaji said, yes, in that case, one of the parameter which is claims, that is very important. Without claims, you cannot complete the application. Claim is very important. So this we are talking about, utility patent. We are not talking about design patent. So that is very easy, that we have already discussed what is design patent. So why we are doing this? Why we aren't waiting for it? Why we are not completing our work and then filing it? Because my dear friends, in India, we follow first to file system, that is known as priority date. For example, Dr. Ruksar and Balaji are both into different team. Okay, Balaji is a different team member, leader for a different team, and Dr. Ruksar is a leader for different team. Both are working on a similar lines of invention, so on and so forth. Okay, so in that case, there have to be someone who should guide them. Sudhir ji is as a very close colleague of Balaji. So Sudhir ji really guides him. Ki, listen, Bala, you need to really make sure you file your application, even if your application is not complete, and if you are very confident, you can complete the application within 12 months. Because if there is any conflicts further, the first to file system, the priority date, when you have filed an application, that date plays a very, very, very important role. So if Dr. Ruksar files it later on, in that case, then Bala and Sudhir, since they knew some of the points about the patent filing, they will have an added advantage of it. So that is the reason the priority date plays a very, very important role. Next, what about the convention group of countries? So for example, if we have Ashok ji with us, we have Bhakti, we have Bhavesh ji with us, we have Anupam Dalal ji with us, Deepa, Dr. Arun, Dr. Dr. Indu, Dr. Krishna, Dr. Pushpender Singh ji with us. If they would question me in a team, you said about the Indian patent, you said about priority date, you said about the first to file system, accepted it. Now tell us, if we as a team are working on an extremely credible invention, which we feel it will really have a very good impact worldwide, tell us about how we can have a patent which we can get a worldwide patent for it. Like you said, if you're filing in India, you get only for Indian territory, right? How we can have patent which is applicable in all the countries? Okay, so my dear friends, do you feel there would be any application where with one application you can get patent in all the countries? Do you feel so? Just a random question to you, to this amazing audience. Do you feel so there would be some application for it? With one application you can get patent in all the countries? So we have answer from Dr. Indu. Thank you, Dr. Indu, for being so sporty. Thank you. World Intellectual Property Patents. Yes, available, Balaji. Thank you so much for highlighting it. That is an organization. Thank you, Subhaji. Thank you, Mamtaji. So with one application, you can get patent in all the countries. Dr. Krishna, Dr. Ruksarji, thank you so much for putting it up. So just to make it more clarity for it and give you an answer for this, there is no such application, my dear colleagues, my dear seniors. There is no such application on. There are a group of countries who have come together for the initial filing process. Like I said, every patent has their own territory, right? So if you file a patent in India and so on, Bangladesh, Sri Lanka, Singapore, Dubai, and so on and so forth. So they came out like WIPO, like Balaji has said, World Intellectual Property Organization, the WIPO they were working on it. Why not to create a single initial filing process? The examination, the grant will be for a specific countries. So only single filing process have been created. So that is known as a convention group of countries. So one is known as PCT, one is Paris Convention group of countries. So one is a group of 148 countries, second is a group of 176 countries. They have come together for a single filing process for the initial level, not for the grant level. Because even in initial level, if you have to apply in 148 countries at 148 application, so the time and the money, the economic factor plays a very, very important role in that. So it becomes really difficult. So getting patent in throughout all the countries, it is very difficult. It is very time consuming, more than that. So that is the way it really works. WIPO is just an organization which helps you in catering your application. That's it. So that is the basic overflow, how your patent application is processed. Even if you want to have an application in 3-4 countries, where if, for example, Dr. Deepak, Dr. Indu, Dr. Krishna, Dr. Pushpendra Singh, Dr. Raja, they are into one team and they feel yes, my innovation, my product plays a very important role in European countries. So they will make sure that they will only patent their product into European country itself. So that is the way it works. So you need to really channelize key and see what is the growth for your product and what is the future scope and acceptability in that particular country. So that is the way you move ahead and you earn your royalties in that particular segments. Let's go for the next one. So that is jurisdiction, my dear friends. The head office is in Mumbai. So Mumbai caters the following states and union territories, and just nothing to read about it. Just for your references, there are 4 offices in India, but still, online application is there for you. You don't have to physically visit for it. If people would question me, if you can just brief us about the documentation, if we have the invention part, everything is ready, how do we go about it? So the documentation part is very simple. The only one thing which is not so common in other documentation, like in over here in patent application, like every 5th line is numbered, okay, on the left hand side. So for example, if you have 20 lines over here, so 5th line is numbered 1, 10th line number 2, 15th line is number 3, 20th line is number 4, and so on and so forth. So that is something key point over here. Rest all the points are very regular points, so I don't need to focus much on it. So we have spoken few things about it. Now, like one of the few important points, all the contents are ready, the invention points are ready, our team is ready for it. Let's talk about the forms, which are the key forms which are used for the patent filing. So these are the forms, my dear friends: Form 1, Form 2, Form 3, Form 5, Form 26. Form 1, Form 2, Form 3, and Form 5. I'm just not reading the complete statement. I think that's completely visible to everyone. So 1, 2, 3, and 5 are compulsory forms, my dear friends. My question is to the amazing audience over here. Is Form 26 compulsory or not compulsory? C or NC? Just you can type C or NC. Is Form 26 is compulsory or not compulsory? C or NC? That's it. You can just comment on it. So before you leave the presentation, you should know what are the forms which are required for the patent, how your patent application is processed, once your patent is granted, how things really work with the patent, and so on and so forth. So it's completely optional. Form 20 is completely optional for it. Okay. So once you submit your patent application and then once you complete your application, then you request for the examination. So once you request for the examination, my dear friends, you request for the examination with Form 18. Form 18A is just to expedite your application. That's it. Just like how we have in passport, we have a Tatkal facility, right? Similarly, in patent also you have a Tatkal facility. That is the way it works. Earlier, the system was a little slow, but nowadays the application, the process, the examination part is expedite. So that's the reason you are seeing year on year, the percentage of people applying for a patent is really high. Nowadays, earlier you didn't used to see even the school children have started applying patents for it, because the government have taken initiative of starting a tinkering lab like 3.5 years back. So even people over there are designing products by using 3D printers, and they're applying for patents for it, for their own design patents. Because I said there are 2 categories: design patent and utility patent. So whenever your students are trying for it, if they're into 2nd year and 3rd year, start showing them what exactly the design patent is all about. Make sure they start trying from the 2nd year itself. So by the time they reach the 3rd year, they will be having a clear idea about the patent, the importance about the patent, and so on and so forth. So in 4th year, in that case, you can really expect them for a utility patent. You cannot expect a utility patent directly in 4th year. It is very difficult. That is my take. Everyone have that different kind of intellect. I'm not questioning on the intellect, but this is a pattern what I feel key should be followed. So it will become easier for you to have a very good utility patent which can have a good impact in society as well as commercially. So after having an overview about, so this is a basic filing fees. There are 3 different categories: natural, mid-level, and 3rd level. So Natural is where all the educators can apply in that category, the professors and so on and so forth, academicians. And second is the mid-level companies who are having an investment between 10 lakhs to 2 crores. And third is about 2 CR. So that is the way they have divided for it. There are two types of filing we have already discussed. Every category have e-filing as well as offline filing. So as I said, key e-filing is always cheaper than the physical filing. Okay. So that's the government official fees, my dear friends. You can just see either what is the actual examination fees, because whatever fees you see it, that is the advocate and the patent agent do charge you, or the third entity company charges you for the services they you avail for it. But the actual government fee is very low. The complete patent application gets finished into 14,400 rupees. The complete application from the application till the grant stage. If you wish to file your own application, if you face your examination and you can tell your grant stage, it is 14,400 rupees. And if you go with the Startup India registration, your 80% fees are relaxed. So that's a benefit you get from government. It's just a small overview about the form numbers and which are mandatory, which are not mandatory, and the fees for it. Just a brief for you. So let's understand how exactly the patent is processed. So assuming we have 146 attendees as of now. So let's understand how exactly, for example, the complete, all the family of 146 attendees who are there. So we all went together, form an ABC company, and we apply for a patent application. Okay. So once you apply for a patent application, my difference, how your application is processed step by step, and what are the points where you'll be facing difficulties and how you can resolve that. So let's understand the complete journey for it with this. So you'll understand the complete journey for it. So your step number 1 is application for a patent. Okay, so once you apply for a patent, can someone in the chat room can say which are the form numbers which are compulsory for the patent application? Just can you number it? The form numbers. It will really help you in revising some stuff, because what is important, what you take away from this webinar, because you are giving your precious 45 minutes to me. It really matters to me. So what are the form numbers which are really required for the applicant? The compulsory form numbers. Thank you so much, Dr. Saida, Dr. Ruksar, Balaji. Thank you so much. That form number 1, 2, 3, and 5. Thank you so much. Thank you. So these are the compulsory form numbers which are required for it. Next question to this amazing audience is, once you apply for a patent, does it require a complete application, or with a provisional application you can also file your patent application? Yes or no? Is it compulsory to have a complete application, or with a provisional application we can also go with it? So the point is, even if your application is not completed, even with the provisional application, with the abstract and drawing, you can go ahead with your application, my dear friends. Thank you so much. Thank you. Thank you. Next question to this is, what is the duration it is given by the government, right, to complete your application? What is the maximum limit, the duration is given by the government to complete your provisional application, to convert your provisional application to a complete application? Thank you so much, Dr. Duksad, Poonamji. Thank you. Thank you. Thank you, Dr. Rutika. Thank you, Balaji. Thank you, Ganprit Kaurji. Thank you. Thank you, Mumtaji. Thank you. Yes, let's go for next one. The publication time. Usually early used to take 18 months. Now it has been expedited to between 3 to 6 months, my dear colleagues. In fact, in some cases, the government has also given into 45 days too. Okay. People have also questioned me before we were starting the presentation. What is the difference between the publication and the grant? So the basic difference that before the examination, it is termed as publication. After the examination, once it is cleared, it is known as the grant stage. So if you would question me, Awab, what is the maximum duration? What is the maximum duration that it will be straight into the publication stage? So the answer is straight away to your presentation screen. It is written 48 months is given from the date of application. Within the 48 months, you have to request for the examination. Till 48 months, you again get ample time to just prepare yourself, to keep on revising your stuff and so on and so forth. But once you cross 48 months, you are public. Even if you are published, that is gone. Again, you have to reapply for it. Okay. So once you request for the examination, you prepare for the examination, so on and so forth, and you give response. We as a complete family, right, as a ABC company, will be giving the response to the examination team. So the applicant found in the order, either the controller, as I said, key like how we have directors in a campus, management in a campus. Similarly, you have a controller in the campus who gets the decision for it. So either the decision could be yes, or other decision could be the no, right? So let's go on a positive note. What if, my dear friends, we as a family, if the decision is yes, let's talk on positive note. If the decision yes, the patent is granted. And you would say, a few minutes ago, you said about in India, we have opposition, right? We have pre and we have post. What is pre? Like even before the grant, people can oppose it. And even after the grant, people can oppose it. Yes, that is right. And once even the patent is granted, my dear friends, you get a 12-month window. Within that 12-month window, people can oppose your work. And then you have to reply for it. Whatever the patent is granted, even if the patent is granted, my dear friends, for the Priyanka, the fees is same. Okay, whatever the patent is granted, then it is open for 12 months for the people to object it. Okay, and if there is an objection, my dear friends, there will be a committee which will form by the controller, and then we have to face it, right? Both the party have to face it. The people who have objected it and people who have got the patent. So there will be three major solutions for it, right? So number one, to maintain the control of year, both the parties and the controller will say, okay, no, what we have granted to this entity, this is whole complete family of 140 people who are attending, the patent is perfect and it will be continued. What you are objecting is invalid. So the patent will continue. Second option. Second option, the controller would say to us, right? To us, I mean the complete family of 148 people who are attending over here. So the controller would say, no, listen to us. The point is that there are few claims which have been said by the other entity. It makes sense, it is valid. You have to change so and so points and so claims, and then your patent application will be processed, it will be granted. So you need to make some amendments, some changes which is required. And before going to third stage, let's understand, what if the answer were no? If the answer is no, my dear friends, the patent is refused. Like I always said, my dear friends, the patent is something like you can always fight for it. Even if the patent is refused, you can appeal for the appellate board, like how we have a district court, right? Similarly, we have appellate board. But then you can put your application over here, and the appellate board will have a hearing. If the appellate board will feel the decision taken by the controller is wrong, then they will take the patent allowed, and then it will be followed with the patent granted, and it will be continued in a similar fashion. And whatever the appellate board feels, the decision taken by the controller is perfect, it's completely correct, then it is rejected, and that is the way it is floated. Okay, and the third option is the controller will say no, the third entity who have claimed it, all the claims are perfectly fine, and there have been the major objection against your patent is rejected, and again you go to the appellate board and the cycle continues. Okay, so this is the overview, my dear friends, how your patent application is processed from your application till your grant stage, my dear. Just an overview, just to make an have a complete idea about it. So whenever you discuss with your students, it will really help you. So just to make you understand with the complete process, the complete steps, and the time duration which is required. This is a maximum time duration which is required. That's the reason I've written it. Maximum time duration which is required. Balaji, I haven't read the claims points, so I won't be the right person to put down points for it. So the claims which is it is really required for it to comment on the Samsung and Apple fight. Because ultimately the patent is granted on the claims. So the claims, people have to really know the claims for it and what claims they have lost it. Dr. Sayadaji, commercialization as in like once you have a patent for it, every patent you automatically gets a right for commercial, because that is a property, that's an asset for it. So either you can give it on license, either you can sell your patent. So that's just a journey. Durations I've just highlighted with colors just to make it easier for it. Poonam ji, I have a question. Patent of addition. For example, Poonam ji, I assume what you're saying, what you're questioning it to me, like, for example, you applied for an application for a patent, right? And by God grace, you have already got a patent has been granted to you in a span of 18 to 20 months, for example. Okay. So, and you are still continuing that work. And again, you could find some good few findings, and that findings which you feel it is I cannot get a independent patent on it, but what I can do is that my existing patent, I can add an additional document to it, and that is possible. That is possible. But just make sure your life of the patent is not increased, right? So life of the patent is from the initial, the filing date, from that date is still 20 years. Okay. Your life 20 years doesn't start after the grant. It starts from the application date. You can keep on adding and you can keep make your patent powerful day by day. That is not a question about it. But the life starts from the application date. Priyanka ji, it is something like technological transfer. It either you say it ki commercial or again it is in a commercial fashion. Like for example, if I have an ABC technology with me, you have an XYZ technology with me. Instead of me paying it to 1 rupee to you, right? For example, and you paying it to me 1 rupee to me to buy my technology, what we do, we have a TOT, transfer technology. I give my ABC to you and you give your XYZ to you on XYZ terms and condition for it, XYZ duration for it, and for a defined territory for it. So that is a TOT. So again, indirectly, it is nothing but a commercialization, right? Because that is your intellect property. That is what you have made it. So you're giving it instead of giving a hard cash for it or liquidity to it, you are giving your asset to it, and in return you're getting a someone else's asset. So indirectly, it is a commercialization. Yes, it is different. It varies, ma'am. Yes, Anupam. The broader guidelines have been made for it. The broader guidelines are there for the at least for initial timeline. But so like I'll take you example, Dr. Anupam Dalalji. Like for example, in US you have a software patent too, but in India you don't have it, right? So there are different rules for different countries, but the initial filing process they are with the PCT and Paris Convention, they have made it easier, but they have the different set of rules because that patent is valid only in that particular territory. So they are not bound by someone else. Few common points are, but not all. So like people have commented, right? One of them, a person has commented key how we can commercialize. So these are the major 3 points, my dear colleagues, like either selling the product or licensing it or selling a patent. So major three where you can have a commercialization with your patent. So this is very important. So this is something where you can make sure you can make your student really understand, especially in second year. You need to have a market survey and make sure this all 4 points are taken care of it. I won't read it because that is completely understood. So this point plays a very, very important role. This is something specifically for the students' point of view. This coming 3-4 slides, just to make sure your second year students are well versed with it and they can think in this direction and start working on it. Can we get grant for publication? No, so publication, like we have already seen Balaji, like publication is something once you submit your application, it is published and you get a serial number for it. You get a unique number for it, but within that 48 months, if you don't go for the request for the examination, then that is discarded. You have to face the examination. Then only that publication gets transferred to the grant stage. For publication, you get a serial number. You get something, you get serial number. You can also say, yes, I have published it. But you have to make sure that if you want a grant stage, because the grant stage only adds value to it. When you talk about commercialization, when you talk about TOT, the publication stage doesn't have any value. Only the grant stage has a value. So this is only a student point of view. I don't want to explain because there are many seniors in this attendees who are there who are much ahead than me. So just for a points, just for a glance. This is something the way the startup companies or the technological companies do it. So these are the main key points how you can also channelize your student, because what I say to all the academician, like at least wherever I go for it, I say stop saying the project, start saying the word product, because the psychological plays a very important role. When you start saying the word product to the students, so they start thinking them yes, someone will be using it and someone have to buy for it. Why when someone will pay 10 rupees for your product? It has to be useful, right? It should add value to it. So start using the word product, so it will be very useful. So they either it could be a software, either it could be hardware, or it could be a combination of both. Whatever it is, it should be a product. They should start working and they should start making product, not project. So that is really important, because ultimately it should be something that someone should pay for it, or either it should be socially be very impactful, either it should make life easier, whatever it is. I've got one patent and learned sub step of the process and wanted to commercialize the same one. Priyanka Patel ji, you have assuming like what you have shared is like you already have a patent for it. And is it something you're collaborating with other entity? I'm assuming that you're collaborating with some other company, or you're giving the rights to it, then only you make an affidavit. And whatever affidavit you make, that has to be make sure that it is reported to the patent office. That's the reason we have seen on the slide the patent agent register. So all your transaction is mentioned over there, because any legal fight, you need to make sure with that something it is wrongly used or piracy is happening for it. The patent, it has to be mentioned. All the transaction has to be mentioned with the patent register. Then only you'll be getting a support from the government of India, right? So with the future, the R&D department, so few of the points where the student have to be very sure about it, because like the major presentation is all about keep making our students work on product and our students work on the patent and so on and so forth, because all the learned person, they, I think the major agenda is all about students right over here. So IP audit plays a very important role, my dear friends. For example, if assuming ki like Bharati Vidyapeeth have an IPR cell, an IPR cell, you already have a patent for it. You and that patent has been transformed to a company, and you make sure that every 12 months you have an audit for it. Because if you are earning some royalty income for your patent, or if you are giving a license to a patent, you need to make sure you should have an audit IP audit company who will give you, who will channelize you keep what is happening, and who will keep on updating you keep what similar patent is being published, what similar patent is being granted, and similar lines about similar lines of your product, or your design or your invention. So you will also get on kick-ass ki bhai, theek hai, yes, even I have to keep on developing new entities, new products. My lifespan of the product would be such smaller because there is a competitor who is already published or already have been granted a patent for it. So IP audit helps you in all this parameters. So this IP audit is impactful only when you're having a commercialization of your patent. Only in that case, my dear colleagues. So just an overview about it. Like few of the people said, yes, how we can have an this thing. We can search the patent for it. Yes, we have the coming slide for it. I think I've crossed my deadline. With the permission of this, can I take more 4 minutes? I'm sorry. Sorry, I couldn't.
Yes, sir, you can. Totally.
Yeah. So just to make sure ki all the audience ki there are people like I'm assuming ki like you might have also spoken to few patent agent, you have spoken to few advocates who do the filing and so on and so forth. Like of earlier I should do it officially, now since because of the tech company, so I completely focus is into the different sectors. But just to make you realize ki whenever you have an interaction with some other entity, right? How do you judge it? How do you make all the documentation with your patent agent, patent attorney, and so on and so forth? So you should realize ki, what are the number of hours that person should dedicate to your work, or else if not, you don't want to hire it. And if you want to realize ki, what is the number of hours, what is the efforts you need to put down, right? You need to put down on your work. So I have just made it much easier for you. People who have attended, people have not even who have not attended. This slide wasn't there previously. So this slide I have just added because few of the people have given me feedbacks that they wanted to know the number of hours which is required by a professional or which is required by an academician, and every step. So these are the major 3 steps. Patentability search. This is very important. What is already there into the market, what is competing with your product, and so on and so forth. Next is patent drafting and filing. Step number 3 is answering the examination and hearing it. Right. So every step I have divided into much a detailed pattern. So first step, it takes all the detailed parameters with number of hours. I have just bifurcated to make it much easier for you to understand what is required. If you want, you can just take a screenshot from your mobile phone, whichever way it is easier for you. So that's the stage number 1. So it takes 30 hours, my dear colleagues. your stage number 2, your patent drafting, and so on and so forth. Each and every categories have been mentioned ki how many number of hours is required. Either your patent agent, either by a patent attorney, either by you. If it would be you, my dear friends, the hours would be 10 to 20% more high, slightly higher. But try to invest by your own, because even if your patent is not granted, my dear friends, first or two in first case or second attempt or third attempt, but in fourth attempt you would be very thoroughly been, because in that case even you and your students can really make sure can float that journey of patenting. So that's a stage number 3, my dear friends. Every category is bifurcated with number of hours, just to make you understand ki what is the efforts and time required for it. Because I should not be very lame ki bhai it is very easy, bhai chalo ho jata hai. It should not be that. So what is required is required. That's a third stage answering examination. Every entity has been mapped with number of hours, my dear friends. That's the complete journey of it. Over here, the Google patent search, my dear friends, someone had questioned me into the chat room, sir, where we can have a prior patent search. Over here, when you go for Google patent search, you can get a worldwide patent for it, India as well as some other entity as well. So this will really help you whenever you are planning for any invention with your students, either with your academic colleagues and so on and so forth. Make sure you start teaching to your students how to have a Google patent search in second year itself. It will have a extremely impactful. Even that third semester, you teach them just to have a patent search. Even that is fruitful. You have already crossed your 50% of your mark. The remaining 50%, they will know ki what not to make. Even that is really important, my dear colleagues. So that's a few web links where you can have a look. I'll do it. I'll just copy the links and give it to you in the chat room itself. Okay, just give me a minute. I'll just wind up with this. So this is a link where you can have a patent search free of cost, where people were questioning about it. So this is something just to motivate you, but you guys were already motivated than me. So thank you so much for putting your precious time and spending your 53 minutes with me. Really appreciate. Thank you so much, Bhati Vidyapit and Huda. So thank you so much for trusting me because and giving me an opportunity to interact with your team. Thank you, Priyanka ma'am, and sorry for extending time. So just ask this three questions to yourself and make sure your students also are asking these three questions to themselves. Can this be made? Can we make it? Can we sell this? If the answer is yes, then go for patent. So have a lovely evening and Eid Mubarak to everyone.
Sir, first of all, thank you. It has been a very, very interactive session. Everyone in the session has engaged with you on the chat window, and you have been very, very modest in answering all the questions wherever they came from, whatever was their intensity. So it hasn't left me with much scope to ask questions at the end of this session. And we're looking forward to many more such sessions because this was very interactive. From the beginner to a professional, everyone could understand some bit of it. I'm sure this insightful session would have enlightened the participants about the real life applications, which is pretty evident from their responses in the chat window. I would now request Professor Huda sir to kindly present a certificate to Mr. Awab Habib Faki sir as a token of our remembrance of this session.
Thank you so much, sir.
So,
Thank you.
Mr. Awab, thank you so much. This certificate is not for the purpose of certification, rather to ensure that you keep on remembering this fantastic lecture session, which we started after a gap of almost a month. And we'll keep on bothering you. This topic of IPR is very important. Probably we all have to understand, and that is how you have also explained that in coming time, instead of making bank balance or purchasing gold or making big houses, it will be more important for educated people to safeguard their intellectual property right. And that was the topic of this, right? So thank you so much, Mr. Awab. And it was a fantastic session. What about memento, Priyanka?
Yes, a memento is also right after the certificate as a little
Absolutely.
gratitude token from our BVI Camp family, sir.
Thank you. Thank you so much.
And thank you so much, Awab. You might have noticed that as part of change, we have changed the bouquet, certificate, and memento from hard copy to electronic copy,
Yes.
right? And thank you so much.
Thank you so much. Thank you.
Dear participants, this meeting room is converted to a facilitation center. and Priyanka and my other team members are here. You fill up your feedback form and see to it that you get certificate. And if you have not registered for forthcoming lecture sessions, do register. 4 other sessions have already been notified. Thank you so much. Wish you all the best. Over to you, Priyanka.
Thank you, sir. Dear participants, thank you for joining us. Please find the feedback form link from the chat window I have just shared with you. Please fill up the same to generate your certificate of participation. Please note that this link is active only till the window is open. Once we close the window, we may not be able to help you. Also, we will not share this link on Gmail or WhatsApp or any other medium. Please enter the correct data in the feedback form as you need in your certificate. We are here to help you till this chat window is open. Awab sir, thank you so much.
Thank you. With your permission, ma'am, can I leave?
Yes, sir. Please, sir.
Thank you so much, ma'am. Thank you.
Thank you, sir. Dear participants, please fill the feedback form link from the chat window. You have to fill them up to generate your certificate of participation. Please note that this link is active only till the window is open. Once you fill the link and your certificate is generated, it will come on the email ID that you have filled in the link. Once you receive the certificate, you can feel free to leave the chat. Please feel free to leave the room once you receive the certificate. Please ensure to enter the correct data in the feedback form as you need in your certificate. I have sent the link again, dear participants. This video will also be available on YouTube on our channel, BVI as soon as the session has got over. Dear participants, once you have received the certificate on your email ID, you are welcome to leave this session.